Okay, I'm going to read Constitutional Protection for Medical Care Decisions on page 1069 of Constitutional Law. Another major area where the Supreme Court has considered the existence of a fundamental right is with regard to medical care decisions. Specifically, two major issues considered by the courts are whether there is a constitutional right to refuse treatment and whether there is a constitutional right to physician-assisted suicide. The right to refuse treatment. Generally, there is a constitutional right of individuals to refuse medical treatment, but it certainly is not absolute and can be regulated by the state. For example, Jacobson versus Massachusetts, the Supreme Court upheld a Massachusetts law that required vaccinations. The court allowed the law because the government's compelling interest in stopping the spread of communicable diseases. In Washington versus Harper, the court said that prisoners have a right to be free from involuntary administration of antipsychotic drugs. The court observed that prisoners possess a significant liberty interest in avoiding the unwanted administration of antipsychotic drugs under the Due Process Clause of the 14th Amendment. The court therefore said that the forcible injection of medication into a non-consenting person's body represents a substantial interference with that person's liberty. However, the court said that the interest was adequately protected by providing an inmate with notice and a hearing before a tribunal of medicine and prison personnel at which the inmate could challenge the decision to administer the drugs. The most important case thus far concerning the right to refuse medical care is Cruzan versus Director, Missouri Department of Health. So in Jacobson versus Mass, Supreme Court upheld vaccine requirement because of the state's interest in stopping spread of disease, of communicable disease. So I guess we're going to read Cruzan next. Washington Harper is also here, but I think we're going to read that case later. But I'll write the holding from page 1069, because sometimes that's better than reading the case. In fact, I may flag it. Cruzan versus Director, Missouri Department of Health. We learn the Chief Justice Rehnquist delivered the opinion of the court. Petitioner Nancy Beth Cruzan was rendered incompetent as a result of severe injuries sustained during an automobile accident. Co-petitioners Lester and Joyce, Nancy's parents and co-guardians, sought a court order directing the withdrawal of their daughter's artificial feeding and hydration equipment after it became apparent that she had virtually no chance of recovering her cognitive faculties. The Supreme Court of Missouri held that because there was no clear and convincing evidence of Nancy's desire to have life-sustaining treatment withdrawn, under such circumstances, her parents lacked authority to effectuate such a request. We granted certiorari and now affirm. On the night of January 11, 1983, she lost control of her car. As she traveled down Elm Road in Jasper County, Missouri, the vehicle overturned, and Cruzan was discovered lying face down in a ditch without detectable respiratory or cardiac function. Paramedics were able to restore her breathing and heartbeat at the accident site, and she was transported to a hospital in an unconscious state. An attending neurosurgeon diagnosed her as having sustained probable cerebral contusions compounded by significant anoxia, lack of oxygen. The Missouri Trial Court in this case found that permanent brain damage generally results after 6 minutes in an anoxic state. It was estimated that Cruzan was deprived of oxygen from 12 to 14 minutes. She remained in a coma for approximately 3 weeks and then progressed into an unconscious state in which she was able to orally ingest some nutrition. In order to ease feeding and further recovery, surgeons implanted a gastrostomy feeding and hydration tube in Cruzan with the consent of her then husband. Subsequent rehabilitative efforts proved unavailing. She now lies in a Missouri State Hospital in what is commonly referred to as a persistent vegetative state, generally a condition in which a person exhibits motor reflexes but evinces no indications of significant cognitive function. The state of Missouri is bearing the cost of her care. After it had become apparent that Nancy Cruzan was virtually no chance of regaining her mental faculties, her parents asked hospital employees to terminate the artificial nutrition and hydration procedures. All agreed that such a removal would cause her death. The employees refused to honor the request without court approval. The parents then sought and received authorization from the state trial court for termination. The court found that a person in Nancy's condition had a fundamental right under the state and federal constitutions to refuse or direct the withdrawal of death-prolonging procedures. The court also found that Nancy's expressed thoughts at age 25 in somewhat serious conversation with a housemate friend that if sick or injured she would not wish to continue her life unless she could have live at least halfway normally suggests that given her present condition she would not wish to continue on with her nutrition and hydration. The Supreme Court of Missouri reversed by a divided vote. We granted certiorari to consider the question whether Cruzan has a right under the Constitution, which would require the hospital to withdraw life-sustaining treatment from her under those circumstances. So this is PC. The court found, so the district court found that a person in Nancy's condition had a fundamental right. At common law, even the touching of one person by another without consent and without legal justification was battery. The notion of bodily integrity has been embodied in the requirement that informed consent is generally required for medical treatment. The informed consent doctrine has become firmly entrenched in American tort law. The logical corollary of the doctrine of informed consent is that the patient generally possesses the right not to consent, that is, to refuse treatment. The principle that a competent person has a constitutionally protected liberty interest in refusing unwanted medical treatment may be inferred from our prior decisions. In Jacobs v. Massachusetts, for instance, the court balanced an individual's liberty interest in declining an unwanted smallpox vaccine against the state's interest in preventing the disease. Just this term, in the course of holding that a state's procedures for administering antipsychotic medication to prisoners was sufficient to satisfy due process concerns, we recognize that prisoners possess a significant liberty interest in avoiding the unwanted administration of antipsychotic drugs under the Due Process Clause of the 14th Amendment in Washington v. Harper. So the principle, the common person has a constitutionally protected liberty interest in refusing unwanted medical treatment may be inferred from our prior decisions. But determining that a person has a liberty interest under the Due Process Clause does not end the inquiry. Whether respondent's constitutional rights have been violated must be determined by balancing his liberty interest against the relevant state interests. Petitioners insist that under the general holdings of our cases, the forced administration of life-sustaining medical treatment and even of artificially delivered food and water essential to life would implicate the competent person's liberty interest. Although we think the logic of the cases discussed above would embrace such a liberty interest, the dramatic consequences involved in refusal of such treatment would inform the inquiry as to whether the deprivation of that interest is constitutionally permissible. But For purposes of this case, we assume that the Constitution would grant a competent person a constitutionally protected right to refuse life-saving hydrogen and nutrition. Petitioners insist that under the general holdings of our cases, the forced administration of life-sustaining medical treatment and even of artificially delivered food and water essential to life would implicate a competent person's liberty interests. The difficulty with petitioners' claim is that, in a sense, it begs a question. An incompetent person is not able to make an informed and voluntary choice to exercise a hypothetical right to refuse treatment or any other right. Such a right must be exercised for her, if at all, by some sort of surrogate. Here, Missouri has in effect recognized that under certain circumstances, a surrogate may act for the patient in electing to have hydration and nutrition withdrawn in such a way as to cause death. But it has established a procedural safeguard to assure that the action of the surrogate conforms as best it may to the wishes expressed by the patient while competent. Missouri requires that evidence of the incompetent's wishes as to the withdrawal of treatment be proved in clear and convincing evidence. The question then is whether the United States Constitution forbids the establishment of this procedural requirement by the state. We hold that it does not. So that's the real question. Whether or not Missouri's clear and convincing evidence requirement comports with the United States Constitution depends in part on what interests the state may properly seek to protect in the situation. Missouri relies on its interest in the protection and preservation of human life, and there can be no gainsaying this interest. As a general matter, the states, indeed all civilized nations, demonstrate their commitment to life by treating homicide as a serious crime. However, the majority of the states in this county have laws imposing criminal penalties on one who assists another to commit suicide. We do not think we do not think a state is required to remain neutral in the face of an informed and voluntary decision by a physically able adult to starve to death. But in the context presented here, a state has more particular interests at stake. The choice between life and death is a deeply personal decision of obvious and overwhelming finality. We believe Missouri may legitimately seek to safeguard the personal element of this choice through the imposition of heightened evidentiary requirements. It cannot be disputed that the Due Process Clause protects an interest in life as well as an interest in refusing life-sustaining medical treatment. Not all incompetent patients will have loved ones available to serve as a surrogate decision makers. And even where family members are present, there will, of course, be some unfortunate situations in which family members will not act to protect a patient. The state is entitled to guard against potential abuses in such situations. Similarly, a state is entitled to consider that a judicial proceeding to make a determination regarding an incompetent's wishes may very well not be an adversarial one, with the added guarantee of accurate fact-finding that the adversary process brings with it. Finally, we think a state may properly decline to make judgments about the quality of life that a particular individual may enjoy. In our view, Missouri has permissibly sought to advance these interests through the adoption of clear and convincing standard of proof to govern such proceedings. This court has mandated an intermediate standard of proof, clear and convincing evidence, when the individual interests at stake in a state proceeding are both particularly important and more substantial than mere loss of money. And that is a decision Stanowski v. Kramer of 1982. Thus, such a standard has been required in deportation proceedings, in denaturalization proceeding, in civil commitment proceeding, and proceedings for the termination of parental rights. We think it's self-evident that the interests at stake in the instant proceedings are more substantial, both on an individual and societal level, than those involved in a run-of-the-mill civil dispute. But not only does the standard of proof reflect the importance of the particular adjudication, it also serves as a societal judgment about how the risk of error should be distributed between the litigants. The more stringent the burden of proof a party must bear, the more that party bears a risk of an erroneous decision. We believe that Missouri may permissibly place an increased risk of the erroneous decision on those seeking to terminate a incompetent individual's life-sustaining treatment. An erroneous decision not to terminate results in a maintenance of the status quo. The possibility of subsequent developments such as advancements in medical science, the discovery of new evidence regarding the patient's intent, changes in the law, or simply the unexpected death of the patient despite the administration of life-sustaining treatment, at least create the potential that a wrong decision will eventually be corrected or is its impact mitigated. An erroneous decision to withdraw life-sustaining treatment, however, is not susceptible of correction. In sum, we conclude that a state may apply a clear and convincing evidence standard in proceeding where a guardian seeks to discontinue nutrition and hydration of a person diagnosed to be in a persistent vegetative state. The Supreme Court of Missouri held that in this case, the testimony adduced at trial did not amount to clear and convincing proof that the patient's desire to have hydration and nutrition withdrawn. In so doing, it reversed the decision of the Missouri court trial, which had found that the evidence suggested Nancy would not have desired to continue such measures, but which had not adopted the standard of clear and convincing evidence enunciated by the Supreme Court. The testimony adduced at trial consisted primarily of Nancy's statements made to a housemate about a year before her accident that she would not want to live should she face life as a vegetable, and other observations to the same effect. The observations did not deal in terms with withdrawal of medical treatment or of hydration and nutrition. I cannot say that the Supreme Court of Missouri committed constitutional error in reaching the conclusion that it did. Petitioners alternatively contend that Missouri must accept the substitute judgment of a close family member even in the absence of substantial proof that their views reflect the views of the patient. No doubt is engendered by anything in this record but that Nancy's mother and father are loving and caring parents. If the state were required by the United States Constitution to repose a right of substituted judgment with anyone, the Cruzans would surely qualify. But we do not think the Due Process Clause requires the state to repose judgment on these matters with anyone but the patient herself. Close family members may have a strong feeling, a feeling not at all ignoble or unworthy, but not entirely disinterested either, that they do not wish to witness the continuation of the life of a loved one, which they regard as hopeless, meaningless, and even degrading. But there is no automatic assurance that the life of close family members will necessarily be the same as the patient's would have been had she been confronted with the prospect of her situation while competent. All of the reasons previously discussed for allowing Missouri to require clear and convincing evidence of the patient's wishes leads us to conclude that the state may choose to defer only to those wishes rather than confide the decision to close family members.